The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain how to maintain an S corporation. So we're going to talk about what corporate formalities you have to follow if you are an S corporation and why it is important to follow them. So first let me explain why it's important to follow these corporate formalities. A lot of people who go online to set up their corporation on the Secretary of State website without an attorney think they're done and think that they now are obtaining the benefits of a corporation. They're usually wrong. The benefits of a corporation are protection from personal liability from corporate debt for shareholders, officers, and directors, and also some favorable tax treatment. And you can get these benefits even if you're just a single person operating your business and you incorporate. The problem is that even if you're a single person operating your business, you need to follow certain corporate formalities. Otherwise, if someone ever sues you personally, trying to personally collect a corporate debt, the first thing they're going to do is ask to see your corporate book and see that you've actually been holding shareholder meetings and that you actually have bylaws and you've been following the rules that a corporation has to operate under, because if you haven't, they'll be able to show that your corporation is just a sham and do something called pierce the corporate veil to get past the corporation to you personally. And then what you've done is you've paid an initial fee to the Secretary of State, maybe to some online company to set up your corporation, and you've paid annual fees to the Secretary of State, but you haven't gotten any benefit from those fees. Just by having a corporation on the books of the Secretary of State doesn't mean you're a properly set up corporation. And if you're not a properly set up corporation, you're not gonna receive any actual liability protection from the corporation, which is one of the main reasons people incorporate. So, that being said, what do you have to do in order to maintain your corporation and maintain the liability protection that a corporation provides? Let's first talk about the things you have to do at the initial setup stage, and then we'll talk about what you have to do on an annual basis. The first thing you usually do is file articles of incorporation with the Secretary of State, and these are pretty simple to file. This is a simple document that states who your shareholders are and what percentage of shares they own and who the initial directors are going to be, and contact info for your registered agent, which is the person who's going to be receiving official notices for your corporation. You'll also prepare bylaws and have all the shareholders sign off on them. Bylaws are basically a partnership agreement for everybody involved in the corporation. It explains the rules of the game for how shareholders, officers, and directors all interact with each other. It's the internal operating document. You'll then have an initial meeting of the shareholders, and this will ratify the bylaws and select directors for your corporation. These are the people that are going to actually be in charge of running the corporation, and these can be elected annually. You'll have an initial meeting of directors where the directors will select officers for the corporation: president, secretary, treasurer. So this sounds like a lot, but what this really is, when you're working with an attorney, if you are a sole practitioner, you will get a packet that has all these documents pre-prepared for you, and if you're a sole proprietor, essentially, it's not a sole proprietorship, but if you're a single person running the corporation, all you really have to do is sign these documents and make sure that they get into your corporate book. If you have multiple partners, then you're going to want to work with your attorney to make sure you understand how the bylaws operate and what everybody's rights are. And you will actually probably want to have an initial meeting. Now, that might be you two sitting down with the pre-prepared documents that you have with your attorney that just ratify the bylaws and select directors and officers, and signing off on those documents. It's not necessarily a formal boardroom meeting that actually occurs. So again, the more simple and closely held the corporate structure, the closer this is to just signing a couple extra forms that your attorney has prepared for you. The more complicated the relationships between people and the stakeholders in the corporation, the more you actually have to have full-blown meetings and a full negotiation of these bylaws. Some of the other parts of the initial corporate setup that are kind of on the back end are creating a stock ledger And that shows who owns stock in the corporation and includes their names and addresses of any current shareholders. And whenever there's a transfer of stock, it'll show who the stock is transferred to. So this is kept in your corporate book, and a corporate book is basically a binder, a fancy binder that holds all of your corporate documents. And if anybody ever needs to see who the shareholders are, or shareholders have a right to see the corporate book, they can examine this and see who the other shareholders are. You'll also issue stock certificates. This is like a check. It's a legal document that shows ownership of the corporation, and they can be signed over like a check to other people, subject to any limitations on transfers of shareholder interest in the bylaws. Once you have your meeting minutes, your articles of incorporation, your bylaws, your stock certificates, and your stock ledger, you put all these together in a corporate book, which is usually kept at your attorney's office. And again, any interested insiders in the corporation can view these. If you ever do get sued, you're going to want to present a full corporate book to show the other side that you've been following these formalities. On an annual basis, you file an annual report with the Secretary of State, which updates any key information about your corporation. You will have an annual meeting of shareholders and an annual meeting of directors. And this does basically the same thing that the initial meeting does. The shareholders elect directors for the next year, the directors elect officers for the next year, and handle any other business that's brought up. Again, if this is a closely held corporation, just like the initial setup, what you'll do is you'll probably get a packet from your attorney that includes what you have to sign for your annual report and signing off on the annual meeting minutes. What we do with our clients is we give them a questionnaire to fill out about what they want to change. They get that back to us. We prepare the minutes, and they can either sit down and sign off on them together or sign them individually and get them back to us. With annual meetings and initial meetings, you have to give notice to all of the interested parties. So for directors, all the directors need notice. For the meeting of the shareholders, all the shareholders need notice, unless you've just set a recurring meeting date and location. Usually for smaller corporations where it's just a couple of people or just one person, in your documents we have you sign will include a waiver of notice. So you don't have to go through the formal notice procedures. Everybody can just waive notice and sign off on the final document. If there are major decisions that need to be made as required by the bylaws will tell you what decisions need this, but you may need to do a special meeting of shareholders as necessary to make these major decisions. That's mostly like taking on a major loan, and sometimes it'll depend on your bylaws, or selling a large part of the company or merging the company. Major corporate changes usually require a special meeting of shareholders, and these are just like annual meetings. They're documents that your attorney will prepare for you, ratifying whatever change you want to make, and you get everybody's signature. Again, the more complex your corporation is, if it is actually 10 people that are shareholders with different opinions on what should happen, then you may need to have a formal shareholder meeting, and you should have your attorney present for that. And finally, the last piece of the puzzle to maintaining corporate formalities is make sure that you understand your bylaws and follow the bylaws and what is required by them for taking any sort of corporation. So like we touched on with the special meeting of shareholders, there's certain types of actions that just the officers can make on their own. So you elect president, secretary, treasurer, vice president. The management of the corporation can do certain things without getting consent from the directors. Certain things require a vote of the directors. Certain things require a supermajority, meaning a 2/3 vote of the directors. Certain things require a vote of the shareholders. Some things require a supermajority of the shareholders. Some things require unanimous consent of the shareholders. So you need to know what action is required to effectuate whatever change you're trying to make, and the bylaws will state what that is. Again, if we have a single-person corporation, we'll make the bylaws so simple and broad that it basically empowers that single person to do whatever they want without much formality needed, because they're the only stakeholder. The more people you have involved, the more formality is usually required. So that's what's required to maintain your corporation and maintain the benefits of a corporation. It sounds like a lot, but if you have a good attorney, it's very inexpensive and very little time from you. It might be 15 minutes to a half hour of your time a year and a couple $100 a year to maintain these formalities. If you try to do it on your own, it's a lot more complicated and time consuming. Feel free to give us a call at 630-324-6666 if you'd like to schedule a free consultation. We offer free consultations in nearly every area of law, and we have offices all around Chicagoland. If you find this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud. And if you have any questions, feel free to leave a comment in our comments section below the post at learn-about-law.com or below the YouTube video on our YouTube station. Thank you so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.